I don't know. After hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Sunday. Hope you guys all had a great Friday night, Saturday, and now we're on to football Sunday. All right, but let's watch some court. I've got some good ones. The first and third one were recommended to me by Lucy, so thank you very much, Lucy. The first one actually comes from a channel called Court Cam Archives. I don't know a lot about that channel, but it looks like they just put up entire dockets. And this one's I think it's at least over a year old, but it's good. It's a good one. So shout out to Court Cam Archives and Lucy. Before I hit the play button, you already know what to do. Hit the like and subscribe button, do your jump kick backflips, and as always, my link tree is in the description if you like the video that much. Please do. All right, let's go.
So let's go back to the Gilbert case, and Mr. Burdett, I appreciate your patience this morning. I know you've been on for quite a while here. Is that Mr. Gilbert in the Grand Traverse County Jail there? Thank you. Can you say something just to make sure that I can hear you okay?
It's Scotty.
Okay, I heard you just fine. Thank you. This is People versus Kenneth Gilbert, file 211501FY. Mr. Burdett is here on the defendant's behalf, Ms. Chamberlain for the people. So this is the date set for a plea. And is that what Mr. Gilbert still wishes to do then, Mr. Burdett?
Yes, Your Honor. We had an agreement with the prosecuting attorney that Mr. Gilbert will be was originally charged with the 2-year high court misdemeanor offense of resisting obstruction of police officer, and the 93-day operating while impaired offense, and enter into a plea agreement where he will be entering a plea of attempted resisting obstruction of police officer and impaired driving. The attempted is a 1-year misdemeanor.
Okay. Is that a correct statement of the plea agreement, Mr. Chamberlain?
I believe so, Your Honor.
Starting off pretty well, pretty normal right now.
Just 1 minute here.
It does get better. What did he say? What did the defendant say when the judge asked him for a mic check? Can anyone translate what he said?
So the offer then is to an attempted resistant obstructive police officer and impaired driving. Correct, Mr. Burdett?
Yes, sir.
All right. And Mr. Gilbert, is that your understanding of the plea agreement as well? You'd be pleading to a reduced charge of attempted resistant obstruct. That makes the 2-year felony a 1-year misdemeanor and also an impaired driving.
Yes.
Has anything else been promised to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No.
Has Mr. Burdett answered all your questions to your satisfaction?
Yes.
I need to go over your trial rights with you and make sure you understand those before I'm able to accept a plea. So listen carefully. You have the right to be tried by a jury, to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor. You understand that?
Yes.
You also have the right to have the witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand that?
Yes.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence cannot be used against you in any way. Do you understand that?
Yes.
Finally, by pleading guilty, you give up the right to appeal you'd have if you went to trial, and any appeal from your conviction or sentence would be by leave, not by right, meaning it would be up to the appeals court whether to even hear your case. Do you understand that right?
Yes.
And do you wish to waive all those rights in order to plead guilty?
Yes.
All right, then. Is it true then that on, let's see, December 12th, 2020, you were at an address in Sutton's Bay Township, Leelanau County, when you were encountered by Officer Isaac Burfield of the Grand Traverse Band of Tribal Police, and you had some kind of incident there where he arrested you. Is that correct?
Yeah, somebody hit me in the head and crashed my car.
Okay. Well, what were you doing that got Officer Burfield's attention?
Somebody hit me in the head and crashed my car into a ditch.
All right. So, Mr.
I know, right? I know what you're all thinking. Somebody hit him in the head, and then they crashed his car. He didn't crash his car. It was someone else that crashed his car. But he was driving, right? This guy's a ball of joy. This is fun.
Burdette, I'm lost here a little bit. Can you help me out with the voir dire?
Yes, Your Honor. Mr. Gilbert, you indicated that somebody hit you in the head. You know, where you were driving a motor vehicle. Is that correct?
Yeah.
And when you were driving that motor vehicle, I guess an incident happened in the motor vehicle, causing the vehicle to crash.
Can you repeat that, please?
While you were driving the vehicle, did someone cause you to crash the vehicle? Did they grab the wheel or something like that?
Yes, he reached from the back, he grabbed the wheel. There's two females in the car, two witnesses, and yeah, he reached over, grabbed the wheel, swung me in one part of traffic, swung me into another, and I tried hitting the brakes, I straightened it out, and we went into the ditch.
Okay. And when you're in the ditch, did the police arrive at some point?
Yeah, about 5 minutes later.
Okay. And did they have you do? Did they? Well, and speaking with you, did they have you do some field sobriety tests?
Yeah, passed them. Then I started telling them what was going on, and I just got mad because he wouldn't listen because they fled down the road, and well, he kind of scared me because there's news reports of like people dressing up like cops and acting like it. Then I got scared because I didn't know what was going on because my head hurt. He ended up hitting me in the head several times with a phone while I was driving and while I was sitting. I just kept getting more and more mad about that. And he had the fat lady and the one dude and just fleeing down the road while he's sitting here telling me, "Oh, don't worry about that." It's like I could have a concussion right now. I have mental issues and I have like brain damage, and getting hit in the head is not good for me.
And I know you're homeless as well. Is that correct?
Yeah, that too. Majorly. I'm more concerned about my health, but I know like nobody else is.
Well, Mr. Gilbert, did there come a time where the officers tried to arrest you and you resisted the arrest?
Yeah, I got scared. I got mental problems that caused me to like basically black out, forget what I'm doing, and just want to get away from the situation. It's just something that takes over me. I got schizophrenia, PTSD, ADHD, ADD, OCD. I got dyslexia, insane. I got, I believe autism too now. And I got Tourette's.
Okay.
Now, I know this isn't anything to joke about, but what does he not have? He just, I don't believe he has all those things. That's why I'm kind of poking fun at him. But, I mean, he could have some of them, I guess. All right. I love how I paused it on his attorney being like, what is going on? And I want to, the prosecutor, bottom middle, he tries really hard not to laugh a few times during this. So make sure you're checking him out as well.
And when they arrested you, I mean, you would say that you weren't following their direction, their orders and what they wanted you to do, and struggled with the police. Is that correct?
Oh, I did what they want for the most part, but the minute they kept telling me that they won't go get or even call backup for down the road, I just kind of quit. I sat in the car. I just refused to get out because I felt scared.
Okay. And they wanted you to do. Pardon?
I said I just had a huge tragedy happen. The cops looking at me dumbfounded. I'd ask him if he could not let somebody who assaulted me with a phone and who almost caused us all to die. And he's just looking at me like, I don't give a shit. I'm here to fucking bother you. I don't care if you lose your tooth, your health, your brain, or even killed everyone in the car. As long as you ain't dead, you're going to jail if I can help it. So that made me think he wasn't a real cop.
Okay.
Usually, a cop's supposed to protect land, not sit here and just harass something that's just in a ditch.
Okay. And Mr. Gilbert, they wanted you to do a chemical test? Did you refuse that?
Oh yeah, until he went and actually addressed the problem. I don't care if you can't do your job, and this is more important. Like I said, it's just on me, I suppose.
Okay.
He could be going down and harassing a whole farm full of people down there and be like, I didn't know. Nobody called.
Okay. Well, did you have anything to drink that day while you were driving?
No.
Or you're driving?
I mean, the only thing I had was probably I was a morning drinker that day, but that's about it.
Okay. And did you smoke some marijuana that day too while you
No, I
operated the car?
No, the lady next to me is a patient.
Okay. All right, because we had some results from Michigan State Police that indicated that.
Blood test.
Yeah, you had you went down to Munson to do a blood test. Is that correct?
Yeah.
Okay. And it came back with a blood test. Came back, Your Honor, with a presence of marijuana and a alcohol of 0.043, and the allegations are that he was impaired due to the consumption of the combination of both.
All right. Well, is your Mr. Gilbert, are you contesting whether those test results were accurate?
Oh, I don't know how long it stays in your bloodstream. I just know I drank quite a bit that morning, so I just know I wasn't I was driving perfectly fine. I was stable and everything, but like I said, nothing, it was just getting hit in the head is what caused me. So I can't really say if it is or isn't. I don't know how long it stays in your system. I know marijuana stays in your system for a month or more. Depends on how much you smoke. So I can't really say. I'm not going to testify.
Well, let me ask you this. Based on what you had to drink that morning and the marijuana, do you think that your ability to drive a car was visibly impaired, meaning another driver might have noticed that your driving was off because of the consumption of alcohol and or the marijuana?
I'm going to say no.
And right there, we don't take a plea. Judge can't take this plea. But 0.043, he's not even half of the 0.08. So, or he's right above half. And if they're not putting on record the amount of marijuana that was in his blood, I don't know if you can do it from the same test or if you have to do two multiple tests. And I don't know what the number is off the top of my head, but now that it's legal, there is an actual amount in your blood that they can test to find out if you're over the limit. It doesn't sound like they have any evidence against this guy to charge him with to continue this case. He's taking a plea deal. Why? Because he got into a wreck? Why aren't they investigating that? It sounds like the easy way out by the prosecutors in this defense, in my opinion. This guy's story is kind of wild. Don't get me wrong. But it doesn't sound like they have very much evidence to fight this at all. Or, no, I said that backwards. They don't have enough evidence to proceed with this case, is what I meant.
Okay, well, I'm not going to accept the plea then today. The defendant has not admitted to facts that would establish an impaired driving. So let's see. We'll set this for a preliminary examination at a later date.
Your Honor, if we could, this is a remand for the circuit court. If we could just schedule this for another plea date and give me a
all right. Well, so Mr. Burdett is hopeful that maybe this will be maybe that we can fix this plea or something, but I don't know. The defendant was pretty clear. Defendant was pretty clear that he wasn't impaired or intoxicated. So anyhow, we will give Mr. Burdett another opportunity to speak with his client. And how long do you think you need? My next Sutton's Bay Day, 2 weeks?
16th.
The 16th. Is that going to work?
Yes, Your Honor. I mean, I was wondering if I could speak with my client, if we could do it maybe Grand Traverse next week. I mean, he's in jail right now, and I don't want him to sit in jail any longer than he has.
Well, that's no fair.
I'd have no objection if they want to meet in the breakout room.
Okay, well, I think it was.
Judges, he's been in and out of jail on bond violations and in failure to appear issues, and he's served a fair amount of time on this already.
Okay, well, I think it would be better though to give Mr. Burdett some time to sit down with his client and hash this out. So we'll put it on a Grand Traverse Day, but let's make sure we'll have a Leelanau prosecutor available for that. So go ahead and set that, Ms. Odom.
And I might just let everyone know that in this case, he's on a PR bond that I can tell. I don't know if he's a remand from circuit court, so I really don't know what bond he's on, but our case, he's got a PR. So he's not getting credit is what I'm trying to tell you for the time he's sitting.
Okay, he was arrested at a bond.
All right, right there. You got the court clerk giving out very important information that the attorney should know. If he's already been in jail sitting on this for a long time and he hasn't gotten any credit, I just see this defense attorney's dropping the ball on this. I don't know him. This is the first time I've ever seen him. I don't know what court this is, but I've got a lot of issues. This guy's story does not make sense. And I'm not saying he didn't do something wrong, but he was below the legal limit for alcohol. They don't have numbers for how much marijuana was in his system. How do you go forward with this? And it sounds like they're trying to get this resolved so they can move on to another bigger case. If he's sitting in jail because this is potentially a bond violation, and they don't even have proof that this was a bond violation, I have a lot of issues. But I don't know. They don't talk about the other case, so I really have no idea. This is just what I'm assuming. I just think this guy's being done dirty right now. But his story is wild.
Violation, the judge remanded him to jail. So at this time, we're just requesting the court cancel the bond. If it was
all right, we'll cancel the bond. And we'll figure that out at a later date, so.
Okay.
All right, pick a date then.
No, I am right now.
Okay.
All right. So next week we're looking. Okay, so how about Friday the 9th at 9:45?
Yeah. I think
Okay, so, Mr. Donaldson, you'll make someone available from your office on that
Yes,
date?
Your Honor.
Okay, great. All right, then we're all set for today unless there's anything else for you, Mr. Burdette?
We had a waiver of a preliminary examination for Mr. Core.
Ah, okay. Let's see. And where is Mr. Kors? Is he in the jail? He's
No,
on
not.
bond. Oh, he's not. Okay. So,
All right, this
we're
should
all
be over
set
now.
then for today, Mr. Gilbert, and we need to get Joshua Core now.
All right, yep. Telling you. You know my opinions. Let me know what you guys think. Am I way off? Am I on point? What do you guys think? I'm not an attorney, but I've watched a lot of court, so I've got my YouTube law degree, right? Just my thoughts. Again, I don't know the entire story, but that just doesn't add up. All right, we're going to another plea deal gone wrong. All right, this isn't as wild of a story, but it's kind of funny. All right, let's go.
It looks like you had failed to appear on November 9th, 2023, and when you failed to appear, I issued a bench warrant. That's why you're there in the jail now. But despite that background, Mr. Lapham, have you been able to stay in contact with Mr. Trush?
Yes.
All right, Mr. Trush, by way of status, then what should the court be aware of?
So, Your Honor, I did have an opportunity to talk to Mr. Lapham. I don't know if the court intended to address the non-appearance of the bench warrant. When I spoke to him, he did intend to take advantage of the plea offer that's been made in this, which would be to admit to count one with all the enhancements being dismissed.
All right, and so just for the court or for the counsel's benefit and Mr. Lapham's benefit, I don't plan on addressing a failure to appear other than the way I've already addressed it. Meaning I addressed it with a bench warrant, and so I don't plan to address it further unless and until the attorneys file a motion or ask me to set a hearing regarding it. But regarding the plea offer, is that a correct statement of the plea offer, Mr. Rolla?
That's the plea offer that was extended on April 10th, yes.
Mr. Lapham, did you hear all of the terms of the plea agreement?
Yes, I did, Your Honor.
Is that how you wanted to proceed, is by accepting those terms and entering a plea?
Yes.
If you could raise your right hand for me then. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. So, Mr. Lapham, under this plea agreement, you're going to be pleading guilty to the offense known as controlled substance possession of methamphetamine. That offense is a felony offense, and the maximum that you could ever face for that felony is up to 10 years in the state prison system and or a fine of up to $15,000. Are you aware of that?
Yes.
If you plead guilty to that offense, then the benefit is that the prosecutor would dismiss all of the other enhancements. So you're charged right now as a second or subsequent offense notice and as a habitual offender fourth offense notice. The habitual offender fourth offense notice means that if you were convicted with that enhancement, you could be subject to life maximum in the state prison system. So are you aware that that enhancement is going to be dismissed?
Yes.
Are you also aware that the second or subsequent offense notice enhancement will also be dismissed?
Yes.
Then understanding the benefit of the plea agreement and having the enhancements dismissed and understanding the maximum that you could face for controlled substance possession of methamphetamine, how do you plead to that offense?
Guilty.
If you plead guilty, Mr. Lapham, you no longer have any automatic right to appeal. And what that means is any appeal following a plea is by leave granted. You also need to understand that you will lose all of your current trial rights if you do enter a guilty plea. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have a right to have the witnesses against you appear and to see, hear, and question them. And you would have the right to have the court order any witnesses on your behalf to appear at the trial. You'd also have a right to remain silent at your trial and not have that silence used against you. And you would have the right to testify at trial if you chose that you wanted to. But if you plead guilty, those trial rights are gone. Do you understand all of those things?
Yes.
Because you're giving up your right to trial, you also necessarily give up the right to challenge other things that you could have potentially challenged if you did have a trial. Are you aware of that?
Yes.
So outside of the plea agreement that we've talked about on the record, has anyone promised you anything else to get you to plead guilty?
No.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yes.
And is it your own choice to plead guilty?
Yes.
The prosecutor claims, Mr. Lapham, that this offense happened on or about November 20th of 2022, right here in Otsego County. Does that date sound accurate to you?
All right, now we get to the fun part. Got to get the boring part out of the way. Got to hear everything that's going on before you get to the fun part. Now, I'm not going to lie to you. I've got a lot of questions. And I'm going to rely on my comment section and my chat to answer these questions for him. But I'm not going to ask him until this video is over. Also, this guy's Judge Colin. So you already know that I'm going to watch him. He's got a great name.
I guess so.
All right. Well, back in November of 2022, were you residing or present within Otsego County?
Yeah.
All right. And while you were here on or about November 20th, 2022, is it accurate that you knowingly or intentionally possessed the controlled substance methamphetamine?
No.
How could I find you guilty of possessing methamphetamine if you didn't possess it, Mr. Lapham?
I didn't know it was method.
Well, let's go through it this way. Did you possess a controlled substance?
Yes.
Did you know it was a controlled substance?
Yeah, I thought it was my Adderall.
You thought the methamphetamine that you were found in possession of was your Adderall?
Yes, sir.
The way you say my Adderall leads me to believe that you're claiming you had a prescription for or legal authority to possess the Adderall. Is that right?
Those two, the couple of Adderalls I had, I borrowed from a friend because my prescription wasn't ready yet.
So let's break this down a little bit further. You possessed a controlled substance that you thought was Adderall, right?
Yes.
At the time, you did not have any prescription for or other legal authority for the possession of that controlled substance. Is that right?
No.
It's not right? Or you didn't have the prescription?
The prescription wasn't ready for another day or two.
So in other words, when you possessed it, you did not have legal authority to possess it. True?
True.
Later.
All right, already. Is he going to accept this plea or not? The judge. I wouldn't. He's wavering. So the story is he has a prescription for Adderall, but his Adderall wasn't ready. I don't know if it's a refill that he has to wait, every 30 days to get however much he was prescribed. I don't know. But he got meth. He had meth when he thought he had Adderall. How can you be charged with possession of meth? Because you have to have the intent and knowledge that you have possession of it, right? He didn't. He thought it was Adderall. Now, is Adderall considered a controlled substance without a prescription? It probably is. I don't know. I don't know where Adderall falls on the drug scale, but it might. But it's still not methamphetamine.
It was determined that that substance, in fact, was methamphetamine. Is that right?
That's correct.
And you don't dispute the fact that it, in fact, was methamphetamine. Is that right?
I didn't know it was.
Well, but do you dispute it now?
I'm sorry, what?
Do you dispute it now? In other words, do you disagree and think that it actually wasn't methamphetamine, or do you agree that it was methamphetamine?
I agree it was methamphetamine.
So with that clarification, then, is there an adequate factual basis?
People are satisfied the court has sufficient factual basis to accept the defendant's guilty plea as to count one as entered.
The defense agrees there is an adequate factual basis.
Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
Yes, Judge.
Yes, Your Honor.
And are the attorneys aware of any promises, threats, or inducements that have not been disclosed on the record?
None by the people, thank you.
I'm aware of none, Your Honor.
Mr. Lapham, I then accept your plea. I find it to be freely, knowingly, and voluntarily given, and I'm convinced there is an adequate factual basis to accept that plea. So I'll accept the plea and enter it on your record. The next step is a member of the Department of Corrections will reach out to you there in the jail. That will be for an interview, and that interview will result in what's called a pre-sentence investigative report. Once you get that document, you need to go over it very carefully with Mr. Trush. Then ultimately, I'll bring you back in front of me in person for a sentencing hearing. So unlike this hearing via Zoom, the sentencing hearing, you'll be right here in the courtroom, so will the attorneys, and so will I. Do you have any questions about that process, Mr. Lapham?
No, Your Honor.
Also, anything further for today?
Nothing from the people, thank you.
I do just want to make one clarification because I had to. I would like the Department of Corrections to be aware of this. So Mr. Lapham was arraigned via Zoom from the Antrim County Jail. He's never posted a bond in this case. So when he was released from Antrim County, I don't know why he wasn't brought here in the first place. But I want the department to be aware he's never posted his original bond since arraignment.
All right, so assuming that can be clarified and accepted as accurate, what you're trying to say more specifically is you think he's entitled to credit for all of the time. Is that right?
Correct.
All right, so if that can be clarified, great, and if it can't, I'm sure I'll hear from both the department and Mr. Rolla. Any further comment by either the department or Mr. Rolla?
No, Your Honor, thank you.
All right, we'll see you in about a month's time, Mr. Lapham. Thank you.
Thank you.
All right. Here's my question. Whether or not you agree that that should have been accepted or not, my question is, I don't see. I'm trying to think how to word this. How do you mistake Adderall for methamphetamine? I am completely naive. I couldn't tell you what methamphetamine looked like, but I'm pretty sure it doesn't come in a pill. And Adderall comes in a pill, right? That's my question. This is me being naive. But he quote unquote borrowed Adderall pills and they were methamphetamine. But so, yeah, someone please let me know. Because again, I admit to being naive on when it comes to pretty much every drug out there. Because I really don't take anything. I don't even take Advil. Ibuprofen. I don't take anything. All right, last clip. Last clip is, it's only about 2 minutes long, and that's all you need. It's a good laughter to end this video because it's funny. This is a good one. This one, again, thank you, Lucy, for sending this to me. It's a great way to end the video. It's a great way to kick off the Bengals game. So if all goes as planned, this is going to end right when the Bengals game starts or right after. So I'm right, the timing right. So we're kicking off right when the video ends. All right. So I'm going to let this play out. Let my outro play out. Like I said, there's about 2 minutes left of the video. If you haven't liked and subscribed already, please do so. It's easy. Buttons are right below the video. You can see them. If you haven't done your jump kicks and backflips already, please do so. You got to get some cardio in every day. You got to keep your body healthy. And if you haven't donated already, I'm just kidding. If you would like to donate, link tree's in the description. I would very much appreciate it. Please and thank you. All right. Yep, that's it. Until next time. Bye.
Okay. We are on the record calling file number 23149014. The file is entitled Credit Union 1 versus Sheila Robinson. Could I have your appearance, please?
Pardon me?
What is your name, ma'am?
Ben.
I'm sorry?
Sheila Robinson.
By notice dated June 14th, 2023, this matter is set for pretrial today, July 10th at 11 o'clock. It's now 11:57. Plaintiff has failed to appear No good cause of that failure having been shown.
Hold up, I'm here. I'm here.
You're the defendant, ma'am.
I thought you said I didn't turn. I'm like, oh,
Are you
I'm sorry.
Are you suing? Are you the plaintiff or are you the defendant?
Oh, I'm sorry. I'm the plaintiff. I'm
No,
sorry.
you're not. You're the defendant. You're being sued.
I'm sorry. I'm the defendant. I'm sorry. I apologize.
Plaintiff having failed to call that failure having been shown, the matter dismissed without prejudice. We'll send out an order today. Thank you for coming in, ma'am.
Thank you. I apologize.
Yes, ma'am.
Oh.
That's going to conclude our morning call.